Hi, and welcome back to Elder Law 101, the series that I have tried to develop over time, excuse me, in order to help my clients, who are mostly older, deal with a whole number of issues that they might be dealing with as older people. For those of you who haven't seen any of these presentations, my name is Arthur Bergeron. I'm an attorney. I work at Myrick. We're an 80-person law firm. We do all kinds of stuff. We're multi-specialty. We're the biggest firm outside of Boston. Because all of that, everybody gets to do what they like to do. And I like elder law. I'm 75 years old. I like elder law because my clients think I'm young. It's terrific. So the point of this set of presentations is to help you deal with issues really throughout your life. And so what I do through this series, which is a 12-part series, is I follow my friends Frank and Mary, the make-believe couple that I always talk about, and their kids, Peter, Paul, and Mary Jr. I always tell people, if you're old enough to get to the joke, you're old enough to be my client. I've done a series of these presentations. They were designed originally, and I find these work well, as a 12-episode series, which I did over 12 months. I've now revised them all for 2025 because there are some law changes that have happened since I originally filmed this series several years ago. So in the earlier presentations, I'm just going to kind of review what the presentations were. In the earlier presentations, I talked about the issues that Frank and Mary may have faced when they were under 60. Then I talked about, in the second presentation, issues that were kind of issues that people tend to be dealing with when they're in their 60s. They're into retirement mode. How do you deal with any of those issues? I talked about folks in their 70s. When they are thinking about maybe needing to move, dealing with some frailty issues, preparing for issues that they might have to be facing later on. I have a whole presentation on income tax basics for seniors because there are some issues unique to seniors. I talked about folks in their 80s. I then talked about one of the issues that people are constantly asking me about, which is, assuming that either folks have nursing home issues or they want to stay at home in order to avoid going to a nursing home. Why it is that they can always qualify for Mass Health, and people can always qualify for Mass Health. I had a specific series dealing with the last year of your life, because there are some issues that are kind of unique to that period of time when you're getting more frail and trying to deal with issues, death issues. This episode deals specifically with dealing with the things that you left behind. I have another episode dealing with trusts. People are always saying to me, don't I need a trust? Trust, there are all kinds of different trusts. They're meant to solve problems. Depending on the nature of the problem, that changes the nature of the trust. I talk about that. I have a special episode specifically dealing with your kids and your grandkids. That is, how do you figure out how to deal with all of these issues once you have died, regarding things you're leaving to your children or your grandchildren. I have an episode dealing with Medicare planning. And finally, the 12th episode, which is 'Tis the Season, that I originally designed to happen during December, when people need to be are often thinking about giving, but also need to be thinking about tax planning. So the folks that I deal with are my friends Frank and Mary and their kids, Peter, Paul, and Mary Jr. And in these different episodes, I've talked about them while they were both alive. At some point, Frank died, and one of the questions, as far as Frank is concerned, is kind of, well, what happened to Frank after he died? There are any number of things that may have happened to him. No one really knows. Maybe he's in heaven. Maybe he's not. Maybe he got reincarnated as an elephant. Who knows exactly what happened to Frank? What we do know is that he had left everything in this particular case to Mary. But then the question would be, what happens if Mary has died? And we know that Mary has gone. We're not sure exactly what has happened to her, but we do know that she has left some things behind, and the question is how to deal with those. So, dealing with Mary's earthly goods. First, dealing with the remains. At the moment that Mary died, she as a person stopped being, and she turned into remains. There were this remaining body that needs to be dealt with after she dies. So there were kind of a series of questions actually dealing with the remains. So who is in charge of the remains? Well, actually, if Mary left a will, then she can, through the will, specify that the person whom she's named as the personal representative, used to be called the executor of the will, is in charge of the remains. Or she could have left a separate document that says what she wants to have happen with the remains. Oftentimes she will have left that document in the hands of an undertaker, who will then simply follow her instructions. If she didn't do any of those things, then legally the remains are under the control of the spouse, if there is a spouse, and if there is no spouse, then of the children. So in this case, Mary has died, so the remains are in the charge of Peter, Paul, and Mary Jr. It would be really helpful for Peter, Paul, and Mary Jr. if you were Mary, and before you died, you had left some written instructions, whether with an undertaker or someplace, so that the kids won't argue about it, because they're not going to be kind of sure of what to do with the remains. They are sure that they want to make sure that they do what you wanted, but if it's not in writing, they're not going to know what you wanted. So you want to be dealing with that. And you're going to be wanting to deal with things like, so how do you want the remains to be treated? Do you want the remains to be cremated? Do you want if not, do you want the remains to be buried? If they're cremated, where do you want the so-called cremains? That's what they're called. Where do you want those to go? What kind of services do you want? There are a set of issues that you would be doing your kids a big favor if you thought about ahead of time. As I say, the best person to think out those issues with is an undertaker. Go see one, and ideally decide with that undertaker how you want your remains to be treated. You can certainly at that point sign a contract with that undertaker and agree that these are the things that the undertaker is going to do. If you want, you can pay the undertaker ahead of time and then sign a so-called pre-need contract, in which case the amount that you pay the undertaker will be the amount that the undertaker will ultimately get after you die once your wishes have been fulfilled. But the point is that this way you've dealt with the issue, you can just get it off of your mind. Now, in this case, I'm assuming that Mary died owning some assets. There were assets that she and Frank had owned jointly when the two of them were alive. And so when Frank died, these assets simply became hers, and that was that. So often when one spouse dies, there isn't any need for a probate, there isn't any need for a lot of other things. The surviving spouse simply becomes the owner of the assets. Oftentimes the time that these issues come up is when the second spouse dies. So assuming that Mary died owning a house worth $400,000, an IRA worth $200,000, bank accounts worth $200,000, and then she had some stuff. There was the tangible, legally the term is the tangible personal property, the personal effects, the stuff that are in the house. Those could also include a car, though. A car is technically tangible personal property. And then there may be some U.S. savings bonds. There may be kind of this or that, other things that need to get disposed of. So let's just talk about how Mary's kids would go about dealing with those issues. First of all, dealing with the stuff. Now, in theory, the stuff needs to go through the probate process before it can be distributed to any of the kids. As a practical matter, this never happens. What happens is that the stuff that's in the house gets divided up among the kids, or typically most of the things that are in the house the kids don't want, and so they'll simply dispose of them. They might do a yard sale, they might just give the property away, and if I want to buy any of those items from the kids, I'm not going to ask them, well, now, what's your authority to do this? Can you show that there was a probate? I'm just going to say, give me the dishes and here's the money. So there typically isn't an issue regarding the stuff. But if there are particular items that you want to leave to particular people, then maybe you should do a list of who you want to be getting those items. And if you think there might be a fight about those items, then what you want to do is have a will that says, one of the first sections of the typical will says, if I have left a list regarding any particular items that are going to particular people, then that list is going to be legally binding. And that way, if you think there is going to be an argument among people, you can assure that the argument isn't going to happen, because through the will you're saying, look, here's, if there is a list, that's how things are going to get divided up, and so you're going to avoid all those problems. Finally, you're going to be dealing with access to any of these items. Typically, the access problem is regarding a safe deposit box. If Mary died leaving a safe deposit box, if she died and she was the sole owner of that safe deposit box, even if she had a power of attorney and through that power of attorney had given someone the power to deal with things after she died, the power of attorney died with her, just like her healthcare proxy died with her. And so the only person who can get access to that safe deposit box then will be the person who gets named by the probate court through the probate process. To the extent that Mary is trying to avoid probate, the best way to do that regarding a safe deposit box is to have someone on that box with her as a joint owner, obviously someone whom she trusts. Then there's the car. The car is probably the greatest single cause of an inadvertent probate. The probate process is really designed to figure out who gets assets that are owned by someone who has died and who has not left a specific death beneficiary. I'm going to talk about some of the other assets where it's fairly easy to leave a specific death beneficiary. You can't do that with a car. One of the ways to usually avoid the probate process is to name somebody jointly with you as a joint owner of that asset, so that when you die, that person becomes the sole owner. That doesn't work with a car, right? Another way to avoid probate is to put the asset in trust. You can't put the car in trust, right? The best way to avoid probate regarding a car is to make sure, first of all, that you have a power of attorney, and that power of attorney gives your power of attorney agent, which in this case would probably be Peter, Paul, or Mary, or all of them jointly or severally. If you have a power of attorney that names people jointly and severally, the legal consequence is that any one of them can deal with things for you. And then what Mary would do in that case is say she had named Peter as her power of attorney agent, to simply tell Peter, look, if I'm not doing well, which means I'm not going to be using the car anymore, and it looks like I might die soon, take the power of attorney, take my title, which he'd need to have the title in order to do this, go to the registry of deeds, transfer the car to yourself, and then give it to my grandchild, or just tell him what you're going to do with the car. And once again, you have to trust that Peter is going to follow your instructions. But that way, that would be the best way to deal with the car. Otherwise, if you die owning a car with a title, before that anybody's going to be able to sell that car or even give it away, they're going to have to go through the probate process, get appointed as a personal representative, and then use that to transfer the car. Now, this relates to so-called low-value probates. If Mary died and the total amount of the assets that were just in her name it was less than $25,000, and if in addition to that, or instead of that, she just had a car, then instead of going through the regular probate process, any one of the children could at least 30 days after date of death, file a special document with the probate court saying that they wanted to file a so-called voluntary administration, because this is a low-value estate. And in that case, instead of going through the usual probate process, which is more cumbersome and therefore more costly, the court will simply stamp that document saying that it was approved, send it back to the person who filed it, and that person can then, with that document, go to the registry of deeds, change the title to the car, actually close out any small bank accounts. This works as long as the total value of these assets, not counting the car, is less than $25,000. So you can have assets of $2,000 and have a $50,000 Mercedes. That's okay. You can still use low-value probate, right? But if the total value of those accounts is $25,001, this mechanism is not available. What about other assets? So any asset that is jointly owned, as I had mentioned earlier, is considered to be owned 100% by every one of the joint owners. So that if any one of the joint owners of, say, Mary's bank account dies, that person's interest evaporates, the other person becomes the sole owner of the account. So one way to deal with the $200,000 that Mary had in her bank account was to put one of her kids or all of her kids on that account with her jointly with rights of survivorship, so that at the moment of her death, her interest in the account would evaporate, and then the kids would become the sole owners of the account. If she did that, then at the moment of her death, her interest evaporates, the kids can go in and cash out the account right away at any time. So that's a way to deal with that. I should mention, and this relates specifically to bank accounts, that the jointly held bank account is the most common cause of a family feud, where, say, Mary has named just Peter, as opposed to Peter, Paul, and Mary Jr. as the joint owner of the bank account. She dies, Peter becomes the presumptive owner of that bank account. Suppose that she had told Peter, well, you know, what I really want you to do is divide up the money among your siblings. Peter could actually do that, and there were no negative consequences to Peter of doing that, since while technically he is at that point making gifts of money to to Paul and to Mary Jr., there is no gift tax. The point is that Peter can't be obliged to do that presumptively. The only way, so if Peter decides that he's not going to listen to what his mother had told him to do, right? The only thing that the kids could then do, Paul and Mary Jr., would be to file for probate, to get one of them presumably approved as the administrator of the estate of her mother, and then in that role to sue Peter, and to say in that suit, which once again would have to get tried or litigated in the probate court, this was not Mom's intent. Mom's intent was not to leave all of the money to you. She had only put your name on that account as a convenience, right, for her, right? And she wasn't intending to give the money. And then Peter would come back and say, oh, I did so much for Mom. Mom did that on purpose. Mom really wanted me to have that money. And the probate court will decide whether what Mary had done by putting Peter's name on the account was actually to make a gift to Peter of all of that money, or whether he was just holding it for convenience. So this is a common problem. One way to solve that problem, if you're Mary and you think this issue might come up, would be to have a will, and to have the will say, it is my desire that any account that is jointly owned by me and one of my children at the time of my death, or by me and Peter, by me and a particular child, that account will go to that child. Or alternatively, that account will be divided equally among the siblings. If it is in the will, then even if the will doesn't get probated, right? Once the kids have seen that it's in the will and that's where the money is supposed to be, typically the issue will not come up. Nothing will have to get probated. The money will get divided up. Then there are items that have death beneficiaries to them, things like life insurance policies, right? So Mary may have died leaving a life insurance policy to all three kids, right? Or leaving them to each child with a particular share. She may have left a policy to just one child, in which case that child is simply going to get that policy. And there's really nothing that can be done through probate in order to challenge that, right? She probably, in today's world, had an IRA or other tax-deferred funds, or just investment funds at Fidelity or some other broker. And if she had the funds in those accounts, then chances are that at the time those funds were created, she was required to fill in a death beneficiary form. The only time that these assets end up going through, and therefore, as soon as Mary dies, whoever is named as the death beneficiary can simply file a form with the investment company, or with the folks who are holding the IRA, or with the life insurance company, and they're simply going to get a check. None of those funds are going to go through probate. The only time that funds go through probate in these cases, the only time that I've seen, is there are cases where Mary may have, and this is especially true in the case of life insurance policies. Mary may have had a life insurance policy that named Frank as the death beneficiary and didn't name any alternate beneficiaries. Often this would have happened because the policy was taken out years and years ago. Now, in that case, if Frank died first and then Mary died, so there is really no named death beneficiary in the policy, that asset is going to have to go through the probate process. Then finally there is the house. Now, Frank and Mary, when they were both alive, owned the house jointly. So when Frank died, his interest in the house evaporated. Mary became the sole owner. If Mary died the next day, though, the house is going to have to go through probate, unless Mary took some steps in order to avoid having the house go through probate. The most common of those steps are, one, joint tenancy. What she could have done before she died was to put her kids' names on the house with her as joint tenants, so that upon her death, the children would simply become the owners of the house. Another possibility is she could have transferred to the children a so-called remainder interest in the house and kept a life estate. This is a probate avoidance vehicle that a lot of my clients use, really because they end up deriving really two benefits from structuring things that way. First, they keep control of the house, but when they die, they know that the house is not going to have to go through the probate process, because at the moment of their death, their life tenancy expires, the kids become the sole owners. Second, 5 years and a day after they have done that transfer of the remainder interest to their children, that interest is no longer countable or lienable, would no longer be countable or lienable if, in this case, Mary needed to qualify for Mass Health, the Massachusetts name for the Medicaid program. If you want to learn more about that, you probably want to watch the episode that talks about why it is that you can always qualify for Mass Health. So there are ways to deal with keeping the house from going through probate. If Mary hadn't done these things, though, so that there were assets, not counting the stuff that's in the house, but assets that were just in her name, typically assets that had a title to them, like a car or bank accounts or the house, right? Then those assets are going to have to go through the probate process. So let me tell you a little bit about probate. What is probate? The purpose of probate, actually, the purpose of probate is twofold. The point of probate is to figure out, A, who gets what. And the way you figure out who gets what is, if somebody dies leaving a will, then you follow the instructions in the will. If somebody dies without leaving a will, then you follow the rules of intestacy. That is, the rules that apply when there is no will. In Mary's case, if her basic plan was to make sure that when she died, the kids get everything, that's the same result whether she has a will or not. If she died leaving, if she died and Frank were alive, even if the assets had been in her name, Frank would get all the assets. If Frank is dead, then the assets get divided equally among the kids. So that's the first point of probate, is to make sure that the correct people get the assets. The second issue, though, is to make sure that before any of that happens, before assets get distributed to anybody, creditors get paid. Creditors under Massachusetts law have 1 year following the date of death to file a claim against those probate assets. Now, that claim filing process has become very complicated as a result of changes that were made to the probate law about 10 years ago now. So in order if you're a creditor, if you were a creditor of Mary's, in order for you to have a claim against Mary's estate to get paid for anything that was owed by Mary at the time of her death, say if you're a credit card company and Mary owed credit card money at the time of her death, or say Mary had co-signed on one of the student loans for one of the grandchildren, right? These are I'm just giving you the most kind of common reasons why there's a creditor issue. Then in order for that creditor to get paid, first, there needs to be the filing of a probate within 1 year of Mary's death. Second, once that probate has been filed, the creditor would need to have sued Mary's estate in the district court or the superior court, depending on how much money is owed. And then, once that suit was filed, the creditor would need to have filed a notice of that suit with the probate court. Very, very few creditors go through that whole exercise, right? And so one of the things that I often will talk to folks about, if they have in this case, if their mother died and there were credit card bills or there were some other bills, I will often suggest to them, what you may want to do is wait and not go through this probate process until at least a year and a day after your mother has died. Because if you do, and if the creditor hasn't done anything by the end of that year and a day, by the end of that year, the creditor gets wiped out. And if you haven't done anything, while the creditor actually has the ability to file for probate against in this case against Mary, there's a significant cost to them, a legal cost to them up front of doing so, right? The cost of actually filing for probate, getting somebody appointed as the personal representative of the estate, suing the estate in district court, and then filing a notice of that suit in the probate court is time consuming and very expensive to the creditor, so most creditors don't do it. So it may be that in this case, Peter, Paul, and Mary Jr. may decide to simply delay filing for probate. The point, though, is that if there are probate assets, before those assets can be distributed, that year has to go by. So if Peter, Paul, and Mary Jr. decide that there are probate assets that they want to get distributed, and they file for probate, even if no creditor has showed up, because they can never know until the end of that 1 year whether there are creditors out there, they really can't distribute any of the assets until the end of that 1 year period. So that's the point of probate. So, and finally, one of the pieces of probate is figuring out who is in charge. That is, who's the personal representative who's going to manage all of this stuff. So, the probate process. Without it, now, first of all, I'm going to assume that we're doing probate without a will, and then I'm just going to talk about things with a will, which makes things a little bit easier, but it's basically the same process. Somebody needs to file a petition. Any one of the kids can file that petition. They need to decide whether the probate that they're going to file is informal or formal. They can file an informal probate if they're getting the assents of all of the heirs who would have been involved in all of this stuff, right? And that's going to speed the process along of them getting appointed as the personal representative. If they can't get all those assents, or for some other reason they decide that they don't want to go through the informal process, they would file a petition with the probate court saying there is no will, and here we are, here are the people who are entitled to the assets through the rules of intestacy. At that point, the court would issue a so-called citation, a notice to the world, including those kids and anybody else, that says that this probate has been filed. That citation will have a return date on it. It will say that the probate has been filed regarding Mary, and if you have any objection, by so-and-so saying that they want to be appointed as the personal representative of the estate. Once again, this used to be called the executor. The term got changed to personal representative about 10 years ago. The citation will say if you want to file an objection to that, if you want to contest any of this, you have to file that objection by the return day. The return day will be the date that's on that citation. That says you have to file the objection by that date. Typically, the turnaround time from the time that someone files the petition for probate until the time that the citation gets issued, the return day goes by, and the necessary documents get filed with the probate court showing that the petitioner, the person who is filing this probate, has done that notice to all the necessary people, has done the necessary publication in the newspaper. Typically that process takes 1 to 4 months. That really varies depending on the county. At the end of that period, if the petitioner has filed the necessary documents, they filed the citation together with a so-called return of service showing that they took that citation, mailed it to the appropriate people, that is anybody who was interested in this case, did the necessary publication. That package of documents would also include a bond by the person who wants to be named as the personal representative. The purpose of that bond is to make sure that the personal representative, once they get appointed, and therefore have the ability to close out Mary's bank accounts, to consolidate all of the assets, that once they have all of those assets in their hands, they don't just steal them and go away and take them all to Venezuela or whatever. So they would be required to file a bond to promise that they won't do that. Typically, if the total value of the assets is more than $100,000, they'll also be required to file a surety on that bond, to actually get an insurance company to guarantee that if they get all this money and abscond with the funds, that the surety company is going to pay off all of the creditors. So, once they've filed all of those documents, then the court will name, unless there's been a challenge by somebody, the court will name the person who has filed that petition as the personal representative of the estate. The job of the personal representative, once again, is to basically get control of all of the assets and to hold them for 1 year following the date of death, in this case the date of death of Mary, and then distribute them, in this case according to the rules of intestacy. Now, even if the documents were not filed immediately following Mary's death, the petition wasn't filed immediately following Mary's death, and even if the personal representative didn't get appointed until a month or 2 or 3 or 4 months following Mary's death, none of that affects that 1 year creditor period. In any event, 1 year and a day after Mary's death, the petitioner will have the ability to take the next steps. So, once the petition has been approved, the courts will issue so-called letters testamentary. That is the document showing that that there was no will, and that the person who had filed the petition was appointed as the personal representative. The personal representative will then get a tax ID number from the IRS, because the estate of Mary is actually a separate taxpayer, and any interest that is earned on any money that goes into the estate, there'll be the income tax will be owed by the estate. With that tax ID number and those letters testamentary, the petitioner can then go to the bank, create an account in the name of the estate, and go to any other banks where any of Mary's accounts were, have the accounts closed out, and have checks payable to the estate of Mary. The petitioner would take all of those funds, put them into that one big account, use them to pay the bills. The petitioner has the ability, or the person who has been named as the personal representative has the ability to make early distributions from those funds. The only danger with that is that if the personal representative makes distributions, like say Peter gets appointed as the personal representative, there was the house, there was maybe there were some funds that ended up being in the estate, and he decides, because Paul and Mary Jr. are saying, we really want some of this money, and so he decides to distribute it early. Well, if he does that, and then a creditor shows up during that 1 year period, Peter is personally liable to that creditor for up to 150% of all of the money that he distributed early, which is why in most cases the personal representative will not make distributions until the end of that 1 year sale, in terms of that, until the end of that 1 year period. In the meantime, in this case, if there is a house that needs to get sold, Peter, as the personal representative, would have the ability to list the house for sale and to sign a purchase and sales agreement for it. But before he could actually close on that sale, he'd have to go back to the court and get a license from the court, getting permission to do that sale. That process itself will take another couple of months. Peter, or whoever is the personal representative, would also be charged with filing any estate tax return that needs to get filed. There would need to be a return that was filed if the total value of the assets was more than $2 million. More importantly, in many cases, Peter is also going to be responsible for filing any of Mary's income tax returns. So if Mary wasn't good about filing her income tax returns, they're going to be Peter's responsibility to file. He's not personally responsible for paying the tax. The tax would come out of the estate, but he is responsible for filing. And then Peter would wait. He would wait for that 1 year, and then finally wrap up the estate. The way that he would do that is that he would probably prepare an accounting. The accounting would show any of the assets that he had gotten that were in Mary's name when she died, and then was part of and therefore was part of the estate. That would include, in the event that Peter had sold the house, any of the proceeds from that sale. He'd also show any of the expenses that he paid, for example, like maintaining the house or paying any of Mary's old bills, etc. And he would list the people who were named as the beneficiaries, in this case, Peter, Paul, and Mary Jr. He'd probably keep a reserve for himself just in case something went wrong and it turns out that after he makes these distributions, there's something else that needs to get paid. He would typically then send a notice to Paul and to Mary Jr. with that account that shows what he did, what he got for assets, what he did with the money, how much he's proposing to distribute to everybody. And he'd say, if you're good with that account, please sign here. Sign a release agreeing that this account is okay with you, and then I'll send you a check for whatever amount of money needs to get paid to you. Finally, if Peter really wants to be on the safe side, before he does that, he will file a petition with the court for approval of a final accounting. He would also do that if he sent that notice to Paul and to Mary Jr. saying, here's the amount that I want to pay you, and either Paul or Mary Jr. say, oh no, that's not the appropriate amount. Because, for example, Peter, as the personal representative, could list in that accounting the fact that he's paying himself a fee, that he's paying himself for the work that he had done regarding the estate. Paul or Mary Jr. may say, oh, well, you're paying yourself too much money, you didn't do that much work, or you're paying yourself a too high a rate. In any of those cases, Peter could get off the hook, and the only way he can get off the hook is by going back to the probate court, filing that accounting with the probate court, and saying to the probate court, here are the numbers, here are the assets I got, here are the expenses, here's how much I want to pay myself. I'd like you, the court, to approve all of that. And then the court would probably schedule a hearing with any of the other folks that were involved, would review any of the case after the hearing, and would decide whether to approve that accounting. What if there's trouble? What if there is probate trouble? What if you're Paul or Mary Jr. and you're suspicious about Peter, right? Because you think, it's been 2 years, nothing has been distributed yet, the house is still around, there are all these other issues, what's going on? What can you do? Well, you can do a couple of things. First of all, at the end of that year, you can always request an accounting from Peter. You can go to the court and say, I want Peter to send a notice to us, right, and to file one with the court to say what he's done with the money to this point, so we can see whether or not we think that there's something inappropriate here. And or they can always go back to the court and say, Peter just hasn't been doing his job, right? It's been a year, it's been 2 years. We've seen cases where 5 years have gone by and nothing has happened. So we want to simply get Peter removed as the personal representative. We want somebody else to be named as the personal representative. So if there's trouble, that's the way to resolve it. Finally, so that's the probate process. Now that probate process, it has been my experience, costs money. Going through a regular formal probate process can cost, even if there are no fights among the siblings, between $5,000 and $15,000, which is the reason often why people will try to avoid probate, right? Finally, though, as I mentioned, I just went through the entire probate process as it applies when there is no will. What if there is a will? If there is a will, you're going through the exact same process. If there are assets that were just in Mary's name with no named death beneficiary, the same process, except that the personal representative, formerly the executor, would file that petition. We'll still have to get it approved by the court. When the court approves it, the typical will specifies that Peter at that point would not have to file that, or while he'd have to file a bond to confirm that he's not going to steal the money. He typically would not have to get a surety on that bond. He wouldn't have to get an insurance company to ensure that he wasn't stealing the money. That saves some probate dollars. The typical will also say that Peter has the ability to sell the house without the permission of the court. And so it reduces that cost. But other than that, the process is exactly the same whether you have a will or don't have a will. So if you're trying to avoid the probate process, the key is not whether you have a will, but whether you've assured, kind of look asset by asset and make sure that those assets are not going to have to go through probate. Finally, the estate tax. Whether assets go through probate or not, if Mary died with a life insurance policy, or with any of those other assets where she's named death beneficiaries, or with any jointly held funds, all of those assets, while they're not part of her probate estate, are part of her taxable estate. And if the total value of those assets is more than $2 million, then she's also going to need to file an estate tax return. And if the value is over $2 million, she's also going to need to pay an estate tax, unless the assets are going to a surviving spouse, unless the assets are out-of-state property, which don't get counted, or unless there are transfers made to charities. So briefly, and by the way, we've talked about some of these other issues, or I talk about some of these issues in some of the other presentations that I've done. But the goal of this exercise, once again, always is peace of mind. For Mary's benefit, one of the things that she may want to do, especially after Frank has died, is to talk to an attorney to talk about whether or not one of her goals should be to structure things so as to avoid this probate process. I've kind of outlined some of the ways she could do that. She could also do that by putting assets into a trust, and actually that's going to be the topic of the next presentation, of the next episode of this series. It's all about trusts, and among other things, whether you want to use a trust in order to avoid the probate process. So I hope you enjoyed this presentation. If you've got any questions, you can always contact me directly, or you can go to my YouTube channel to watch this show again, or call or email me. I never charge for advice. I hope this has been useful for you, and I hope you will watch any of the other episodes of this series if you find them useful. Thank you very much.